Hello, everyone. I'm Wade Pogany, Executive Director of the Associated School Boards of South Dakota, and we want to welcome you to our series of videocasts that we're hosting around open meeting laws. School boards are always involved in meetings and subject to open meeting laws, and so we want to explore what some of those procedures are and help you have a better understanding of what open meeting laws are about. This session is a two-part session that will deal with executive session and what school boards can do when they enter into executive session. With me today is Dr. Randy Royer. Randy, welcome. Randy is the director at ASBSD for board development. And also here is Gary Kaufman. Gary is the director for policy and legal services. So gentlemen, thank you for joining me today to have this conversation. It's an important conversation around procedures that boards have, and we want to make sure that they have a solid understanding of what the law says and around what they can do and can't do in this. So let's talk about executive session. Why do we even have executive session in statute? What purpose does it have, and why we can even go into these meetings? What does it do for us?
Well, basically, executive session is to discuss items that you do not want to discuss in open session, either by ethics or by law, and the law allows us to do that in certain circumstances.
So these are sessions that are hosted in private because there are certain reasons why we need to do that.
Yes.
Correct?
If I could just interject too, and I'd agree with what Randy had said, he referenced like the law, and the courts have recognized there's a constitutional right of privacy. So when you're dealing with employees, and in that kind of scenario, the government, the school district operating through its board is the employer. There is an employee constitutional right of privacy to some degree. Students, confidentiality, that is governed by federal law, Family Education Rights and Privacy Act. So like Randy said, there's the ethics aspect, there's the business aspect, there's the legal aspect, and then there's the constitutional law aspect as well.
So there's reasons why we would have these meetings because of confidential, private matters, federal laws, state laws that govern that.
Exactly.
The law talks about 5 reasons why we can enter into executive session, and it gives us the ability to go in, but we need to follow those 5 reasons very carefully when we do that. So let's explore this. Boards can go into executive session for purpose of personnel discussions. Is that true?
Yeah, the first clause of the law says discussing the qualifications, competence, performance, character, or fitness of any public officer or employee or prospective public officer or employee. So the board would use this to maybe evaluate a superintendent, or maybe to fill a vacant position on the school board if they had a term that was they need to fill, or like performance, teacher terminations, etc. Those would be taken care of in executive session as well.
So just about anything that would have to do with a personnel related matter could be handled in executive session, correct?
That is correct. Again, as I indicated a minute or two ago, that's the government acting as the employer, and the employer has the right to go into exec session to discuss employee matters. Like Randy said, if it's an employee matter or employee grievance, something like that. One thing I would stress on that subsection is it is employee and public officer specific. The law is very specific that if there is reason for a discussion regarding an independent contractor with whom maybe the board has questions or concerns about performance, etc., the law is very specific that reason for going into exec session does not include independent contractors. Independent contractor discussions must by law be in open session.
Okay.
Like a food service or a cleaning service.
Correct.
Something like that.
Contracted bus service would be another one. Yes.
But teachers, administrators, those are of a confidential nature, so we would have those in closed sessions.
Correct.
Speaking of confidential natures, sometimes and quite often boards are involved in discussions about the welfare of children, and sometimes those are private discussions to protect the child in many cases. So you can go into executive session to talk about a student?
Yes, if you're talking about the educational program of a student or suspension, expulsion, some of those items, and that's to protect the student.
Okay, okay.
And again, as I referenced earlier, that is one that is very formal in terms of the controls in legislation as it relates to student confidentiality. That's federal law driven to where law recognizes the right of privacy of students, and when it's dealing with a student discipline matter or anything dealing with students, that is to be held in confidence.
Okay. Can I enter into executive session if I want to consult with my attorney? Is that agreeable within the statute?
Absolutely, as long as the attorney is directly communicating with the board, either in person, on the phone, teleconference, through letters, through documents, etc. But the attorney needs to be directly involved with those communications.
Okay, okay.
And,
Go ahead.
and the other type of involvement is if a school attorney was talking with the superintendent and recommending, suggesting that be conveyed to the board. Again, that would be the direct attorney involvement. The other thing I would add on that subsection for reason for executive session, the law is very specific. It talks about pending or threatened litigation. That is what we commonly call the attorney-client privilege aspect, but the law is also very specific as it relates to contracts. It is one reason for going into exec session, and that is to communicate with, receive communication from the school attorney. Contract is not a standalone reason. There must be direct attorney involvement. And if it's dealing with a contract matter, boards should be aware that not all contract matters, even if the attorney is present, qualifies for executive session. So there should be some discussion between the school district and its attorney whether or not it even qualifies for executive session, and get that issue addressed before it even goes into exec session.
So I can't go into executive session to talk about buying the bus just because my attorney is sitting there. I can go into executive session to consult with him about a contract, if the purpose is to consult with him.
Right, in terms of getting a legal advice, legal opinion, legal recommendation regarding a specific contract. But like you said, whether or not to buy a bus, whether or not to buy real estate is not a legal issue. That's a governing board policy issue, if you will.
Talking about contracts, is one of the purposes of having executive session also to talk about negotiations and collective bargaining?
Yes.
Okay.
That's the fourth clause of that. To talk about, prepare for contract negotiations, negotiating with employees or employee representatives. Yeah, it's essentially getting ready for those negotiations.
And really to prepare for the negotiations coming up.
Yes.
Correct.
And it can also include not only preparing for negotiations that are just getting started, but to keep the board informed from the board negotiations team if we're meeting with the collective bargaining unit, the Teachers Association, in terms of what the Teachers Association presented to the board's team. And so the board can then always be informed and be giving direction to the board's team on that. The other thing too is and it doesn't happen very often, but if a majority of the school board members are on the board bargaining team, then they are having a meeting. They would have to go into executive session for purposes of negotiation, where then the majority of the board or the entire board would be meeting with the teacher or the teacher representatives. That negotiation session in and of itself can be in negotiations as well.
Okay. So we know we can enter into for personnel issues, student reasons, negotiations, and then consultation with our attorney.
Mm-hmm.
There's one more called marketing and pricing strategies. What is that about?
That's probably rarely used by school boards, but if the school board was in a business that would be conflicting with another business in the community, they could have an executive session to discuss marketing strategies for that business. Again, it's rarely used by school boards because they're rarely in standalone businesses, but if they had an after-school program that competed with the local YMCA perhaps, or a private business, that would be a time then to talk about pricing strategies.
Okay. Okay.
Yeah. The only thing I would add to that is historically that comes out of, and I believe, the state cement plant, business aspects. So again, if a school board was looking at going into an exec session for that reason, I would really recommend it be contacting its school attorney, because it's very rarely used and applicable.
So school boards just need to be very cognizant of the fact that the law very specifically says the conditions by which we can enter into executive session. You can't just decide you're going to go in executive session because you want to talk about anything. It has to follow these 5 principles or these 5 reasons.
And the discussion is limited to just that reason you went into executive session. You cannot stray from that reason you went into it.
Okay.
So if you go in for one reason and then the discussion leads to another direction, it's up to the chair to get them back on topic.
Okay. And then our next series or next video, then we'll talk about the process that we go through and get into that.
If I could add one more thing, it's a Class 2 misdemeanor for violation of executive session rules and laws. And I know we'll talk about this more in the next session, but I think it's important to note now that there are 2 consequences for violating executive session rules. One, it's a criminal violation, and second is that a complaint could be forwarded up to the Open Meetings Commission, and if it's found that there's a violation, then the governing board can be publicly reprimanded. So there are consequences, and significant consequences, for violating the executive session rules.
So we really need to pay attention and follow these 5 conditions then clearly.
Yes.
Thanks for joining us for this first in our series of videocasts, and stay tuned for more issues about open meeting laws.